Good morning, good evening, wherever you are. Welcome to episode 30 of the Cloudcast. We're coming to you live from our massive Cloudcast studios here in Raleigh, North Carolina. On today's show, we're going to be all about how the law interacts with cloud computing. So we've heard from a number of people, how do we get smarter in this space? And as an added bonus, I'm going to try and perform a little bit of a miracle here today. I'm going to be speaking with two attorneys, lawyers who are very, very focused in this space, and I'm not going to pay $1 for any of their time or expertise. So before we get started, our crack legal staff here at the Cloudcast has asked me to read this disclaimer, just so we understand that this is not professional legal advice, so everybody needs to listen up for about 10 seconds. This Cloudcast does not represent legal advice, should not be used as a substitute for legal advice in any particular circumstances. As usual, your mileage and your company's legal analysis may vary. This Cloudcast is not intended to, and does not, create an attorney-client relationship between any of the participants, the listeners, past, present, or future. Okay, now that that's out of the way, let me introduce today's guest. First is Adrienne Mead. Adrienne, welcome to the show. Thanks for coming on.
Oh, thank you so much for having me. I appreciate it. Just by way of introduction, I'm an attorney licensed and based in California, actually Southern California. And my background is as an in-house counsel, and particularly as a commercial counsel, transactional generalist, primarily in the IT telecom industry for a provider of global network connectivity. And more specifically, my professional emphasis was on providing legal support for the Global Channel Alliance go-to-market program, advising the business on all aspects of the full business lifecycle of channel relationships and the contracts associated therewith, and related product development efforts, most recently with British Telecom in the Global Services Division.
Okay,
and
cool.
In a prior incarnation, a long time ago in a galaxy far, far away, I worked as a forensic accountant, which is why I always end up talking about numbers and dollars, and it always comes back to that eventually.
Very cool. Fantastic. So you're going to help us bring an aspect of what's the service provider's view of the world and their legal ramifications, as well as how their customers and enterprise and medium-sized business needs to be thinking in terms of how they interact with large providers or small providers.
Well, I sure hope so.
Good. And also joining us today is Deborah Salons. Deborah, why don't you take a second to introduce yourself?
Sure. Hi, my name is Deborah Salons. I'm an attorney that's also licensed in California and also in Washington, D.C. I'm based in Washington, D.C. I'm also a certified information privacy professional. My practice is focused on telecommunications, media, and new technologies, regulatory law. And since I am located in Washington, D.C., I'm very policy focused. For the past 5 years, I worked at a K Street law firm representing wireless companies. I'm very interested now in exploring the intersection between telecommunications and tech, as well as information security and data privacy issues.
Okay, very, very cool. So we've got, I think, sort of both ends of the spectrums, the operators and the consumers of these things, as well as how does policy influence this, what type of trends are we seeing around where the laws are being built. So I'm excited to have both of you on the show today. Thanks for coming on. Let's start off with something just sort of at a high level. Cloud computing is both has an aspect of new technology to it. It also has a different aspect to business, business operational models. What's the overarching? Where's the legal community stance around cloud computing these days? Where's the current thinking in this space?
Well, I can tell you that lawyers are not technologists. They focus on the law and the business. So when it comes to new technologies, we either come up with creative solutions, but more often than not, within corporations and also as outside counsel, we're usually the no people to a cloud provider or a cloud customer, because we see risk when the laws aren't solidified, and we want to avoid liability and our clients becoming examples. But from my experience as a telecommunication regulatory attorney, just focusing in on cloud and the cloud legal education programs that I've participated in, the focus has really been on what is the cloud. I think that's a question for both technologists and for legal professionals. Yep. But since this is new, this is like we all have to get educated a little bit on what it is. And the focus has primarily been driven with the SLA contract aspects and then the privacy and the policy stuff. So I think as attorneys, we have the challenge of looking to the traditional regulations for telecommunications, commerce, et cetera, and try to apply them, because nothing is really cloud specific at this point. So, and on the flip side, there's no real consensus with technical standards, so it really makes it hard for the law, and the regs are not up to speed at all with the technology.
Okay.
Yeah, I would agree. I mean, I think this happens. I mean, and just to apply an analogy, even in medical ethics, for instance, they as we have new medical procedures and things that are capable, then they worry about the medical ethics haven't kept up with it. So that we've seen this kind of thing in anything. Whenever science or technology moves forward, the law, echoes behind it and tries to find whatever models that might work or be applicable and tries to apply them to that new set of circumstances and technologies.
Okay. So from a practical matter, does that, if let's say you're one of the technologists that's listening to the show, from a practical matter, does that typically going to mean as cloud gets more widely deployed, as it becomes more mainstream, you're going to run into probably a little more sense of the lawyers being a little bit conservative because they want to make sure they're doing their job and protecting their clients or protecting the people that are hiring them for business interests. But there's also going to be a number of gray areas until we get those sort of cornerstone cases that really identify a problem.
I think you're unavoidably going to have some gray areas, but hopefully the lawyers aren't just the people who say no, okay. but can also find ways to make what has gone before fit. And maybe I'll just draw a little bit on my own background. For instance, because lawyers are not technologists, sometimes we have to get, be brought up to speed and help to understand the technology and what it means. And I know, like for myself, just for instance, I used to work on product documentation, mm-hmm. and can you imagine anything more dry, mind-numbing than the product documentation that goes along with your contract that describes the product? For me, that was really dry work, and the documents themselves could be mind-numbing, but I'd always come out of that knowing the products, which were really services in the telco industry, sure. Obviously. Yep. I understand it a lot better. Okay. So that's, I guess, part of it. Help your lawyers understand what it is you're doing.
Okay.
And I think we're also going to it's going to get a lot more interesting because, especially with cloud, we're getting a lot more consumer focus. It used to be that IT, telcos, large, service providers there was no cost effectiveness or very little cost effectiveness to do it down to a consumer level. You were pretty much all B2B for anything that was of any size.
Okay.
But as cloud is coming, we're going to end up having a lot more B2C. So it's going to have to get shaken out, and there's probably going to have to be some standards in place because you've got consumer protection issues now that are going to interplay. I hope that answered your question.
Yeah, no, that's good. And what I'm hoping to do with this show, and obviously the law can either be a very heavy topic or it could go in a lot of directions, is just to make sure we talk about sort of the main kind of top of mind things. Help people kind of get going in the right direction, give them a sense of like where are the major pitfalls, where are the areas that are still very gray. So this sort of insight I think is very, very good. So let me jump into something that is a little bit top of mind for people, but I think it's an instance where people are kind of unsure. So one of the questions that always comes up, whether it's people that are looking to implement cloud technology, and in many cases they're a private company looking to leverage a public service. There's a lot of uncertainty or questions about what happens, what rights do various governments have, not just say the U.S. government but other government agencies. What do they have? What rights do they have to data that's stored in a public service, whether that's an Amazon service, a Google service, a Verizon or a carrier telco type of service? What are the main laws to sort of, or the main guidance that people need to be aware of?
Sure. This is a huge concern for service providers and enterprise both. The question that I always hear is, once I put information in the cloud, what rights does the government have to search it, or any government for that matter?
Right.
There are significant issues regarding privacy of data and data security, specifically as they relate to personally identifiable information as well as confidential business information. So you're looking at a broad array of different types of data and different concerns. Generally, with the U.S. government, there's the search warrant, subpoenas, court orders, the e-discovery, compliance issues. And privacy laws generally provide that companies with personal information must disclose that information when required to do so by a valid court order or subpoena. Now, there are also specific concerns about the United States federal government's right to data stored in the cloud. And I think this is a concern not only of American companies, but also international companies trying to do work with American companies, and that's the U.S. Patriot Act. And just to give everyone a little bit of background as to what that is, the U.S. Patriot Act actually stands for Uniting and Strengthening America by Providing Tools Required to Intercept and Obstruct Terrorism Act. That was passed in 2001 as a reaction to 9/11. It has significant implications for the cloud provider. The act allows the installation of devices to record all routing, addressing, and signaling information kept by a computer, which is the rough equivalent of a computer tab. Yep. And it extends the U.S. government's ability to gain financial and student information even without the suspicion of wrongdoing of those individuals. So the only requirement is governmental certification that the information obtained would be relevant to an ongoing criminal investigation. So cloud providers may find themselves in a position to hand this information over, and the cloud user or the cloud customer may have very little recourse.
Deborah,
I'm sorry. Go ahead.
Sorry, I just wanted to ask one little question here. Now, when you're talking about the Patriot Act, is this only apply in cross-border, or could it be even domestic within the U.S.?
I believe it's domestic. I believe it reaches any U.S. company.
So, I mean, we had heard some years ago about that the federal government was tapping cross-border telecommunications, was listening in on your phone calls. I remember at the time I was involved in a lot of cross-border phone calls, and we would start each conference call with, "Hi," the people listening in. And I just wanted to make a point of clarity, because this is not just cross-border. This just isn't just international. This is even domestic. I'm sorry, I didn't mean to interrupt your train of thought there. So
right, I believe that it's both domestic and cross-border when it involves a U.S. company.
Let me ask a follow-up then to the sort of the government agencies and what rights they have. There was a fairly high-profile case or a high media visibility case in the last couple of weeks. A company called Mega Upload. They were put in place to sort of similar to what YouTube did originally, which was make it easier to share large files. In many cases, these were media files, movies or videos or whatever. The FBI, the CIA got involved, made a determination that this company was some of what they had was pirated information, pirated movies, and obviously there's a visibility to try and crack down on piracy. But so that aside, there was some interesting byproducts of this, one of which the service got shut down. The second was it was at least initially stated that, well, the information resides on third-party service providers' infrastructure, and that would all be destroyed. And it sort of brought up this interesting of like, well, who do as a consumer, as a customer or business, who do I really have my contract with? So if you're my question then is, if I'm a customer, what are the sort of key things I'm looking for in my contracts, my SLAs, to really understand who's my contract with and what dependencies are there maybe behind that contract? Is that typically clear in these contracts or not so clear?
I'm sorry, I'm jumping in here because you mentioned contracts. So.
Yes, I was just going to give it to you, Adrienne.
Okay. I'm trying to understand the question a little bit better, because when you're saying, and it'll just help me from my perspective. So if I'm a customer, or you're saying if I'm a service provider?
Yeah, let me put some names to this. So so business A is they make something. Right, they make automobiles, for example. Right, so let's suppose like Ford Motor was using this third-party service that was basically a file hosting service, because they were going to use it to send around all of their car diagrams to marketing agencies or whatever. But they're really big, so they're using this third-party service, and they have global companies they work with. But the company that hosts the service actually resides on top of British Telecom or Savis or AT&T, and somehow it gets determined that service, that middleman service, has some aspect of what they do that's illegal, right? Similar to what happened to Mega Upload. Who's Ford's relationship with then? Because the assets that hold the data are owned by the service provider. They're sort of rented by this middle service. How does that work from a legal perspective?
Well, obviously, if Ford is signing a contract, they should hopefully know who they're signing that contract with. Right. I think what you're trying to say is what does extend to third parties, and what rights do you have? Third parties. I
guess what I'm getting at is, cloud starts to, because of the way that we can overlay services on top of other services, right? So there's maybe an infrastructure service, but there's an application service that can live on top of that, and they might be owned by different entities. Who's my contract with, and does that always align to the technology that's underneath it?
That's what I'm saying. You end up having to unravel this, right?
Yeah,
you have to unravel technology, and you have to make sense of it. And I mean, whoever you have contracted with, obviously, who Ford or whoever has contracted with, and you cited off some big names in the service provider space.
Yeah.
They would have an agreement with that. Now, to the extent that a third party has also become involved there, it gets messy. Your first recourse and direct recourse is against whoever you have the direct contract with. That's privity of contract, right?
Okay.
To the extent that there's a third party, you would try to reach to the third party, and you would, there's some subcontracting issue. You would try to put that in your contract, that if there is a subcontract, that's a concern for when you're doing your contract, saying that if any of this is subcontracted out, we are also involved with that. We also have the right to act against, this third subcontracting party, or the carrier would say, have to take responsibility for any third party subcontractors.
Okay, so there's
I'm not sure if if I'm completely answering your question.
No. I mean, I think we're probably going to keep coming back to sort of common themes, which is that the technology, the types of new technology that exist with cloud computing, whether it's virtualization technology, which sort of abstracts sort of distinct things that we used to be able to point to before, or it's layered types of services or over-the-top types of services. It's really incumbent upon the technologists, the IT organizations, to have a dialogue, an ongoing dialogue, probably with the legal departments, to start to help them understand that the world's different as we're negotiating contracts, as we're trying to protect ourselves. Like, we need to be thinking, okay, maybe it's not as cut and dry as it was 5 or 6 years ago, when you'd go, my relationship is with this company, and you don't have to sort of go, but let's make sure that, what are their dependencies behind the scenes, which maybe we didn't have in the past?
Yeah, absolutely. And you want to, what you end up having is that you may have to take action or do, or make an issue, raise issue either formally, hopefully informally with your carrier. And you make the issue if there's a contract dispute or some kind of an issue, or outage or whatever it is, you make that issue with your carrier.
Okay.
Then hopefully your carrier will reach back to whoever is also become involved. Because how did these other people get involved? Who brought them in? Somebody brought them in, right? The web gets tangled, right? So it is important. And I really like your comment about making sure you bring the legal people in.
Okay.
Make sure you keep them advised, because I think that's absolutely key, and it's very true, because there's a lot more that the legal department can do to try and protect this, and prevention. Sometimes an ounce of prevention is better than a pound of cure.
Okay.
The more you know and more proactive you can be, the more help your legal department can be. Also, if I can just kind of touch back on something else that Deborah was talking about, when you were talking about government seizure of data and of records, if anything like that happens, if any carrier, any provider has any kind of a court order or anything like that ever served on them, you would want to tell your legal department right away. Even if it looks really official and it's the government and it's all this, you may have a contractual obligation to oppose the discovery under that court order. A search warrant, usually you can't do much about, but you have to make sure you're looking at a search warrant and not some lesser court order, where you may be able to have a motion to oppose that order for discovery. So there's all different degrees of dire, how dire something is.
Now,
so that would be something else you want to make sure you get your legal department involved.
Now, let me ask a follow-up to this, and throughout the, I'll sort of caveat this to anybody listening. Some of these questions may be you guys don't have answers with immediately, so I'll sort of try and keep them simple. So let's suppose let's take a carrier example again. That carrier gets subpoenaed. They get a search warrant on behalf of one of their clients. So they've got 100 clients, and the government comes with a concern on behalf of one of their clients. Do they have any obligation to the other, say, 99 clients to let them know that they've received, they could be completely anonymous about it, but they've received some sort of warrant? And the reason I ask that is if I'm one of the other 99 customers and I know that somebody has placed a search warrant on them, there is at least some percentage chance that there could be some ramifications. Maybe there's an action you can take to back up your data somewhere else, find a secondary type of at least plan B. Is there any obligation for that provider to notify their other clients that something may eventually happen?
Well, I'll take that from my perspective. I can't imagine that any sophisticated buyer of any kind of services wouldn't ask for something like that in their contract. To say, in other words, basically you have a confidentiality. You can't give my records to anybody. My data is my data. Right. Nobody touches it, right? And especially in the carrier world where you argue that you're just providing a pipe. Now that gets a lot blurrier in a cloud context, obviously. Right. But blurrier. So in the instance where you've got a carrier who's providing a pipe and it's really clear it's my data, nobody else's, you can't touch my data. In that instance, you'd have a confidentiality clause. An incident to a confidentiality clause, it's usually you cannot share this with anybody except pursuant to a valid court order. But there's also usually a clause in there that says, and if you receive a court order, you have to promptly let us know and give us an opportunity to oppose the court order. Because we may have valid action. So even if it's affecting someone else, even if I'm not the party that the court order is about, if you're going to provide data, you're going to violate my confidentiality clause.
I gotcha.
If you're providing someone else's data and mine gets caught up, so you're probably contractually, typically that's a typical clause in most contracts, that you're probably contractually obligated to let me know so I can oppose it as well. And I think you may be heading towards something that's in the news, some instances that have happened recently.
Yeah, no, not necessarily. I mean, to some extent, and I'm not trying to point out or call out anybody. To some extent, I'm just sort of asking questions because obviously, the bulk of the listeners to this show are technologists, they're IT managers. They're probably not getting into all the details of negotiating contracts, but it's helpful again for them to know sort of the other side of the fence, and so that's the reason for the question, not so much as a leading question. Now, so Deb, I want to come back to you a little bit around policy things. So we talked about the Patriot Act. Right. I know at one point you and I had a kind of offline conversation where you mentioned there's some other policies that are coming down the road or may have just recently come out around Europe. Can you talk about what some of the trends are outside the U.S. that you're at least keeping your eye on that people should be cognizant of?
Sure. The EU is a great example of something that everyone in America should have their eye on. The EU in general has a different perspective and has a higher value of data privacy than the American law has. So European law looks at the treatment of privacy and the protection of personal information as a human right. So this bleeds into cloud computing, right? Because you're holding information typically of people. Okay. And the EU considers American privacy laws not strong enough. Okay. The EU says that the U.S. laws have to do not provide an adequate level of privacy protection. And in order for U.S. businesses to do work with the EU, in a business that holds any kind of data, they require a separate safe harbor certification, which is a program that's been coordinated between the EU Parliament and the U.S. Commerce Department. Okay. That being said, the EU has this 1995 Privacy Directive, and what it is basically, I'm trying to translate this into non-lawyer speak, but as Adrienne and I know, it's kind of like a model rules. It's an example as to what every single country needs to follow, and then each country makes its own rules using the directive as kind of like a baseline.
Okay.
And just this last week, the EU, well, we've known that this has been coming down the pike, but they have been planning on revising those laws. And so this last week, they made some announcements as to what was going to happen and how they're planning on revising those laws. And the reforms that were announced is that basically they're trying to attempt to harmonize the rules across the EU.
Okay.
So that the member countries would have something fairly similar. The way that it works now is that there is the EU Data Protection Privacy Directive, and each country has their own data protection authority. And so I think this would still be in place, but it sounds like they're trying to make the rules a little bit more, in harmony throughout all the countries. Some of the things that have been mentioned also is like a data breach must be reported as soon as possible within 24 hours. So that's a little bit different. There's a requirement in the public sector for large enterprises to appoint a data protection officer. And, overall, it increases the rights of individuals and supervisory authorities that will most likely, and that itself will most likely complicate American cloud business in the EU or the retention of information of EU citizens. Because, once you have some business that bleeds into this, that has data of EU citizens, or even you have a server in the EU, you're going to be subject to these regulations.
Okay.
And what's very interesting is that a lot of EU companies are now hesitant to work with American cloud providers because of the U.S. Patriot Act. Because if you're an American company, then any of that data that you have that has to do with European citizens or a company or what have you, if you're an American company, you're subject to the U.S. Patriot Act, and the Europeans don't like the fact that the American government can just go in and look at the information.
Sure.
So there is a big conflict of laws there, and I think that might in the future affect business with American cloud companies.
Okay.
Yeah, and it sounds exactly from what Deborah's saying. In order to comply with the EU directives, you end up violating the Patriot Act, or vice versa. In order to comply with the Patriot Act, you violate EU directives. So that's possible. What could happen? It's a possible scenario.
So it's I guess the immediate thing that jumps to mind on that for me is if the world was as simple as you could sort of say, well, this is where I do business and these are the laws, this is where I do business and this is the laws, maybe not such a big deal, but the way the internet's evolved, the way that cloud sort of services are involved, that they've become not just one service. You don't just go to one site on the web. When you go to somewhere on the web or you use a service, it actually is typically a kind of a conglomeration of a lot of different things coming together. It may make it very, very interesting if we're now sort of restricted by where does data come from? Can I actually build services across the internet? But I have to go back to thinking geographically again about am I in violation of laws or am I not in violation of laws? Which I understand. I understand the reasoning for having the laws in place, but yeah, it's going to make things very, very complicated as we get to a more interconnected type of world, or at least even interconnected types of services.
It's full employment for lawyers.
Yeah, well,
right. And just to add on to that, there are specific countries, like for instance, Germany is very protective of its information. In fact, I don't think that you can legally store information from a German company outside of Germany. So it's, you have to also look country by country on top of the EU. And then there's also other policies with like Canada, APAC, Latin American countries. They've got all their own standards and laws and their special nuances and whatnot. So the internet being such a global community and a global industry, it starts, these types of things start creating boundaries, which is very interesting from an infrastructure perspective.
Right. So obviously it's very, very critical for both technologists, but also for the legal professionals to have some sense of where is my data located. Mm-hmm. Right? And there's obviously there's technologies these days that can sort of represent it as if it's in location A, but it's really in location B. So it's critical for people to really have a sense of where it's located, if not so much from the technology perspective, but to make sure that they're in compliance, or if they're moving things around, that they realize the differences between the geographies of where their information is. So let me ask a question, I guess, from a sort of lawsuit perspective, or a precedent perspective. So providers from time to time have outages or services go down that people are dependent upon, and typically there's ways to have recourse around that. Sometimes it's around SLAs, but SLAs tend to be about recouping cost of the lost service, so X number of hours or X number of whatever. Have there been any precedents that either one of you are aware of where somebody has been able to go after one of the cloud providers and try and claim that they lost X amount of business because that was down, or are we into that space yet from a legal perspective? Does that make sense?
Well, I mean, I don't know that there's a successful precedence, but I can promise you that people are trying.
Okay.
There have been some significant outages. I mean, Heartland Payment Systems was a big one. We've had some other even more recent ones, and there have been settlements on these cases, right?
Okay.
So settlements generally are confidential. We don't
Sure.
know we don't know all the details, and so But if there's settlements, that means the plaintiff's bar is getting aggressive, and I think it goes back to what I was saying earlier about when we get B2C versus B2B. In the B2B world, you've got two. At least the concept is you've got two sophisticated parties negotiating, right?
Yep.
So you've got the SLA is the sole and exclusive remedy, and so you get your recovery under the SLA. As we get into more and more customer contracts or consumer contracts, we get B2C, and then there's going to be more issues around consumer protection, and we're going to end up having more and more issues there of what were the consequences of this? Like I said, precedents are tricky, but generally in your contracts, and they're going to, even as it exists now, if you're signing, you do something like a EULA, a license agreement, you click the terms, you click through and agree to the terms. In there, you're agreeing to limit, the other party's liability, and you're agreeing to limiting damages. What you're talking about, the lost business, is something that's called consequential damages or indirect damages.
Yes.
Which any carrier contract, anyone in this space is going to be telling you, is going to be writing contracts that limit or exclude consequential damages. The notion of consequential damages, I'll give you a definition from Black's Law Dictionary. The consequential damages are those injuries or losses which are a result of an act but are not direct and immediate. Isn't that nice? Indirect is not direct. Thank you. That's very clear. Consequential damages resulting from a seller's breach of contract include any loss resulting from general or particular requirements and needs of which the seller at the time of contracting had reason to know and which could reasonably be prevented by cover or otherwise, an injury to person or property proximately resulting from any breach of warranty. So basically, if you could have seen, if it was foreseeable, that's a consequential damage, but most contracts exclude them.
Okay.
So we're in order to be able to profitably provide services, the service providers have put this in sort of a self-preservation. I wouldn't be surprised if some of this, if this is what they're asking for in some of these cases, and in some instances they're getting it. You've also got the issue where there's a limitation of liability, and they try to waive, there's a liability waiver, and they try to waive liability for all kinds of things, and they'll try to waive liability for everything that happens.
Sure.
But typically, gross negligence and intentional acts cannot be effectively waived by contract. The courts kind of don't like that. So you end up having to have what you'd have to show to get past that sort of, we don't give consequential damages and we limit our liability. To get past that, you kind of have to say gross negligence.
Okay.
And gross negligence would be I'm giving you another legal definition here, the intentional failure to perform a manifest duty in reckless disregard of the consequences affecting the life or property of another.
Okay.
So it's a materially more want of care than constitutes simple inadvertence, right? I think you can have a pretty hard time saying that some carrier was grossly negligent, just as a point of fact.
Okay.
I mean, how big do they have to foul up
Gotcha.
to get to that? I mean, the fact is, services have some inherent glitches that you can't say that the connectivity and these things are going to be perfect all the time. And it goes to kind of an industry standard. And the nearest analogy I could give you is sort of with the medicals in a doctor's office. You know,
right.
You can go to the best doctor, the best trained doctor. They can observe all of everything they're supposed to do. But in that waiver that you sign before you go in for surgery, they tell you, you could die still.
Right.
Yeah. You do everything right.
And
so,
I mean, to some extent, and I get where you're going with this. I mean, to some extent, you're, especially with the relationship you have with certain providers. I mean, there's a certain thing that you don't want to say, which is, look, we do the best we can to make sure the service is always available, but wink, wink, nod, nod. Sometimes things break, right? We do the best to make them highly available. We do the best we can to make sure they never go down, but occasionally things happen, they go down, and the white elephant in the room is every person who works on either side of the technology. We know these things happen. Software bugs happen. Hardware fails. Power goes out. And people
satellites wobble.
Satellites wobble. Yeah, things happen. And the reality is you need to sort of plan for that, just like you planned for it when you owned the assets, you ran the service. And you have to figure out what's my tolerance for outage, and then balance that against the cost of whatever additional steps you need to take to make sure that those don't happen as frequently, or they're less impactful as they might be otherwise. So okay,
yeah, exactly.
I just want to add something.
Failure.
I want to add something to that. In regards to like SLAs and SLA repayment, the SLA provides the contractually agreed to level of performance for certain aspects of the service, but SLAs are not required under law, and for the most part, there is no law requiring the use of SLAs. So when you look at it, SLAs were born out of the business need for instance, that outsourcing service providers faced long before cloud computing. They were used as customers were asking for certain levels of contractual levels of quality. So I guess my point is, SLAs are contractual creations born out of a contract, not the law. So cloud providers have no requirement to use SLAs or police them. So I expect that this area of the law, the recuperation of lost business outside of SLA repayment, it's probably going to develop further as time goes on.
Okay, so what you're saying is that in essence it started as a business differentiation, a competitive differentiation, but it wasn't founded in law, it wasn't grounded in law. So there's room for that to evolve or change or go somewhere else.
That's my understanding, Adrienne.
Okay.
Yeah, it's grounded in contract law, so it's
okay.
It's a protection mechanism. It's protection, but it's also it goes back to the other thing about industry standards. What are your industry standards? And I mean, an SLA, in order to even offer an SLA, a carrier or a provider have to do some kind of testing on their network. They have to be sort of up to speed and watching and knowing what their network is doing, right?
Right.
You can't even offer an SLA unless you're sort of paying attention and you're monitoring it and policing it somehow.
Right.
So
right.
It is, it does go both ways, right? The carriers offer to the customer that yes, we're staying on top of things, and it's what the customer gets in case something goes like it's not supposed to. But it's our way of our way. I'm going back to my my former in-house role. It's the carrier's way of saying, here's what we will do, and that's the way of making the contractual agreement, saying this is the standard we will live up to. And it goes back to where I think, going back to the doctor, malpractice thing, you can't make a successful claim against malpractice against a doctor unless you say they were below the standard of care in that industry.
Gotcha.
And so I think SLAs are going to start to be part of the evidence, the basket of evidence and that kind of thing, to establish, well, what is standard in the industry?
Right.
And I mean, we don't have people who are licensed cloud providers, like we have licensed doctors and licensed lawyers.
Right.
But we're going to get to something I think very similar to a professional standard of care.
Okay.
Kind of thing is going to have to develop. I think the courts are going to strive to, because it's something they're familiar with in this other avenue, so they're going to look to apply it here.
Okay.
And it just makes sense.
Okay. So, we've talked about kind of the gap between, the way the legal profession thinks about these things. It's obviously from a protection and from a, basis in rules versus what the technology world thinks of. So there's obviously an opportunity for some education there, for some sort of maybe connecting the dots. We talked a little bit about both U.S. policy and European policy, the difference between them. Obviously, people should be aware of what they look like, kind of have some sense of what they may evolve to. We talked a little bit about how to protect yourself, what ramifications are kind of standard. But let me ask, just to wrap this up, and I'll throw it out to both of you, sort of last question. What's if you were talking to a room of people, and for the most part you were sort of talking to technologists, but you were saying, look, this is what you need to be aware of, this is what you need to be cognizant about, what's that one thing that they all sort of forget, or really just don't, it's never top of mind for them, but is really important from a legal perspective? What's that we don't know what we don't know thing that you hear the most?
Yeah, we don't know what we don't know. Are we channeling Donald Rumsfeld? Well, you have the known unknowns, and then you have
right.
I think what I'm trying to get my head around this, but I think the best thing I can think of, well, aside from what I was just saying about the professional liability professional standards of care, yep, which I think is going to become the norm. I mean, it isn't really completely officially there yet, but it's hard to imagine us not going towards that kind of thing. And like I said, again, especially as there's more B2C, but also that an area that's growing is insurance. Okay. And that, data breach, data kinds of insurance. For one thing, consider a data breach plan before you have a breach.
Okay.
Put a plan in place. If you're going to have a data breach, what will you do if it happens? Because what is it, the old saying, there's only two kinds of people, those who've been hacked and those who will be. So,
right. Okay. Yep.
So figure out if the worst happens, how are you going to deal with it? Just so you've got sort of it's kind of like if you'd have any other kind of disaster recovery, right? You'd want to have this kind of disaster recovery. And then also look into insurance, because at some point you can spend more on security and try to apply more, when we think of typical, security in the cloud space, the security thinkers, we can get them involved as much as possible. But at some point you get diminishing returns. You can spend 4 times more on your security, but you're maybe not 4 times as secure.
I gotcha.
So figure out what the cost benefit, and then you can say maybe we can get some insurance for where there might be a gap.
Okay.
Banks are insured. So this is a growing area. I mean, I don't know that it's going to be cheap insurance, but
okay.
It's a possible safety net.
Okay. What else?
I think I'd have 2 things to share. I think one is one of the legal concerns that a technologist might not think of, because they're very thinking of in the now and what's going on with technology, but also think about keeping access to the data in the long term. And I think in the legal community, we're kind of looking at this like, well, what if a service provider files for bankruptcy? Or what if they merge or they're acquired? Or what if they cease to do business? What happens with all that data? What happens to your concept of business? And I don't think the lawyers have answers to that yet, but that's something to just kind of keep an eye out for a long-term business. And another thing, just coming from Washington, the best advice I think I could give anyone in the industry is really keep an eye on the developments in Washington, because cloud is, like I said before, the laws kind of lag behind the technology immensely. But I know that the FCC, the FTC, Commerce, with the new EU privacy directive, cloud is now becoming a topic here in this town. And you don't want to be developing a product or an infrastructure that's going against the policy trends, because when the regulations finally get passed, you might not have any way to be grandfathered or to even use your technology. So It's really good to keep an eye out as to what's going on here. And then companies also need to get in the game. So if you have a company that has some kind of a product that might be implicated by some kind of policy here in Washington, get some representation, get some lobbyists, and start making some noise about the issue.
Okay.
And I would agree completely with that. And also, you can say, just even recently, making noise and just even stopping SOPA, which may come back. But I totally agree with what Deborah's saying there.
Okay. Well, very
get
good.
Get your hand in the game.
Excellent. Well, ladies, this has been really, really fascinating. I think we probably could cover these topics for hours on end. I'm hoping that the folks that listen into this learned a little bit. They've got a few places to go get themselves educated some more. But thank you so much for your time. I'll sort of quickly summarize the disclaimer we had at the beginning again. This wasn't intended to be official legal advice. This shouldn't be taken as official legal advice. This is just sort of topics of discussion from some folks that live in the legal profession. So don't sue us, don't sue them, don't take this as word of law. Thank you so much to both Adrienne and Deb for being on the show today. We're out of time for the week. For folks who are listening to the show, you can follow us on Twitter at thecloudcastnet, or obviously on the web at thecloudcast.net. You'll find links to the show. You can send us a comment or email, and you can find all the details about how to get the show either on iTunes or on Stitcher. So for Deb and for Adrienne, thanks to everybody for listening, and have a great weekend.